Thanks so much to Patrick, who's one of my dearest friends. I hope everybody here is making just as good of friends as I made while I was in WSPM. And to everybody here at Oxford who's made this so nice to be back. And to my family for being here. So I am hoping that this is a small enough group that this can be relatively informal. So I'm happy to turn it more into a conversation than a lecture if you'd like to. When Patrick and I were first talking about the direction that this could go, the topic that I would talk about, we had suggested talking about tribal water rights in the West. And I thought, well, this will be fairly timely because there's a lot going on right now. When we decided, I did not know how timely it was actually going to be. This is literally within the last 3 or 4 days, a settlement agreement has been reached between the Navajo Nation, the Hopi tribe, the San Juan Paiute tribe, and the state of Arizona and surrounding communities. That we'll talk a little bit more about what that settlement deal means, but it will be a huge, huge deal for water supply in the Colorado River. And people have been paying attention. I don't know if you're quite this nerdy about Colorado River issues, but Arizona, California, and Nevada just issued their proposal to the Bureau of Reclamation for the post-2026 Colorado River sharing regime. So the world that we're talking about right now, could not be more timely. Everything is happening. This map gives you a sense of just how significant tribal water rights are across the United States. There are just around 530 federally recognized tribes in the United States of America. About 230 of them are located in Alaska. You'll see in Arizona how this is a particularly large group in Arizona. There we go. So we are at an inflection point because of several recent developments in the law. Now I'm going to be coming at this from the perspective of Western United States and also in particular from the perspective of a lawyer. So I'm a lawyer, so you're going to get a lot of law, so brace yourselves. And law is about conflict mostly, so it's mostly people suing each other. So we are at an inflection point. I'm going to talk only about 3 relatively recent developments on tribal sovereignty issues when it comes to resources. One is the removal of dams on the Klamath River. The Klamath is on the border between Oregon and California. Several tribes have been part of a movement to remove dams for the restoration of traditional salmon fisheries. And part of this has been the recognition of the legal personhood of rivers. The next is a new approach to how we quantify tribal water rights. So tribes have water rights in the United States. How we go about telling them how much water they have. For the first time in history, we are in the middle of a trial, literally right now in the middle of a trial, to determine a new way to quantify those rights. And then finally, the United States Supreme Court just a few months ago issued its opinion in Navajo Nation v. Department of the Interior, which was in some ways a huge blow to the Navajo Nation, but I'm going to point out some ways in which it might not be quite as bad as some people make it out to be. Before we really dive in, I'm just going to take a minute I'm going to say the word acre foot or acre feet a lot, and I'm just warning you right now. The United States of America has a bizarre way of measuring things. We like to get 20 rods to the hogshead for some reason. But fortunately, I'm here in the UK, and I remember being here with my kids and our doctors here giving us their weight in stones, and me having no idea what the doctor was talking about. So you're at least used to bizarre measuring systems that don't make any scientific sense. So in the Western United States, we generally measure water in acre feet. An acre foot is 1 acre of land flooded to 1 foot deep, or it is 325,851 gallons or 1,233.5 cubic meters. So it's 1 acre foot is a lot of water. Let me give you a really, really basic overview of how tribal water rights work in the United States. The Western United States, largely speaking, recognizes a prior appropriation regime. So it's first in time, first in right. The first person to get there, pull water out of the river and put it to a beneficial use has superior right to that quantity of water at that diversion point for that use over anyone who comes after them. So a farmer shows up in 1890, diverts 10 acre feet to grow corn, and another miner shows up, diverts 10 acre feet to mine copper. In 1 year, there's 7 acre feet in the river. The farmer gets everything, the miner gets nothing. 1 year, there's 12 acre feet in the river. The farmer gets 10, the miner gets 2. Now you hear that and you think, well, what a perfect regime for indigenous people. First in time, first in right. Who's more first than indigenous people? And it works out not as bad as you might think. In your head, you might go, oh, well, I bet that the indigenous people get completely destroyed in this system. kind of. The way that this works is that in 1908, the United States Supreme Court recognized that all tribes have an inherent right to water. This is in the early part of the 20th century. That we must read every treaty between a tribe and the United States government as if it says water, even if it doesn't. So there is an implicit right for all tribes to have water. That case is called Winters v. United States. We sometimes refer to those rights as Winters rights. What is the priority date of a tribal reservation? You might think, well, the tribe started using that water thousands of years ago, so it must be thousands of years ago. It's not. The priority date of tribal water rights is the date of their reservation. As you will see, for most tribes, that is early enough that it puts them at or near the front of the line, but not for all tribes. There are some tribes who were not federally recognized until much recently, and that means that those tribes, when there is what's called a call on the river, the call on the river means there's not enough water to satisfy all the legal rights, and so we're going to cut some people off. There are tribes in Arizona that get cut off. In Arizona, if you diverted water after about 1935, you have what we call a paper water right, meaning you do have a legal water right, but you'll never receive wet water except in certain biblical flood years. So anyone after 1935, every river in Arizona is over-appropriated, which means anyone who has diverted any river in Arizona after 1935 will probably never or very rarely receive water. Now, how do we quantify, or how have we traditionally quantified those rights? They're traditionally quantified by something called practicably irrigable acreage, or PIA, which means we go to the tribe and we say, okay, let's take all the land that you have in your reservation. How much of it has arable soil on it that you could grow crops? And we narrow the land down. And then we go, okay, let's look at engineering feasibility. Can we get the water from where it is to where the arable soil is? And then we narrow it down further based on engineering feasibility. And then we look at economic feasibility. Is it worth the cost of the infrastructure to bring the water where it is to the arable soil to grow crops that will make enough money? And then we narrow it down further. Those practicably irrigable acreage, each acre is then assigned an acre foot based on the most productive income generating crop. And then we multiply it by the number of practically irrigable acreages, and that's how much water the tribe gets. Now, your initial thought is, if you're like me, your initial thought is, what if you don't want to farm? Well, tribes get this water right quantified regardless of whether they want to farm or not. But as you can imagine, for some tribes, this is great. For tribes that have a big fat river running right through the middle of their land and have a lot of arable soil, they get huge water right allocations. For tribes that are way up in the mountains with little arable soil and you have to pump the water up to them, their practically irrigable acreage tends to be very small. They get very little water. This was decided in another seminal case by the United States Supreme Court, Arizona v. California in 1963. During that case, there were 5 tribes that received decreed water rights by the United States Supreme Court. The Chemehuevi, the Cocopah, the Fort Yuma, Crit, or the Colorado River Indian tribes, and Fort Mojave. During that time, the United States Supreme Court declined to quantify or decree a water right for the Navajo Nation, which is one of the reasons that we're in the middle of litigation now. We have traditionally based these quantifications based on a standard called primary purpose minimum amount, meaning that we look at a reservation and we say, what is its primary purpose? And then we award it the minimum amount of water necessary to meet that primary purpose. I have a personal argument that I've made in court many times, which is this standard has only been recognized in cases that have applied Winters rights, federally reserved rights, to national parks and national forests. And so I have said that standard should only apply to national parks and forests. It should not apply to tribes. Courts right now are generally applying that primary purpose minimum amount to tribes. To me, that doesn't make any sense, but the way the courts are articulating it is, what is the primary purpose of a tribe, of a tribal reservation? It is to establish a permanent homeland. How much water does it take to establish a permanent homeland? The tribe's practicably irrigable acreage is basically how the courts are articulating. So let's talk a little bit about the Klamath Dam removal. This is a lot more text on a slide than I normally like to give, but it'll at least give you a sense of how this works. So this is now one of the largest dam removal projects in history. It is following on the heels of dam removal projects in Maine. The Penobscot tribe pushed for dam removals based on similar arguments in Maine. The success of the dam removal in the Penobscot River led to the Klamath tribes pushing for dam removal in the Klamath. So in 1864, these tribes entered into a treaty with the United States government after a series of conflicts, like most tribes in the West. and ultimately had a fairly large reservation. Years of what are called allotment acts after that made it legal for the United States government to take reservations out of trust, meaning all land held by Native Americans is not owned by Native Americans. It is owned by the United States government, who holds that land in trust for the tribe. As you will see, that has significant implications for tribal development. But what the United States did during these series of allotments was to say, rather than us hold it in trust for tribal members, we'll grant the land to tribes in fee, meaning individual tribal members will own the land, not the tribal government. As you can imagine, many tribal members thereafter sold their land. Their biggest buyer was the United States federal government, who just ended up buying much of the land back, then granting that land to the Bureau of Land Management and the Bureau of Reclamation to develop farmland. This led to the development of these dams and to basically the elimination of the Klamath tribe's reservation. This led to massive protests by the Klamath people because they were saying, you're building all of these dams to regulate the flow of the river and you're destroying our traditional salmon fisheries. The government ended up entering into a series of negotiations with the Klamath tribes and several other parties along the river and reached an agreement that went before the United States Congress, and then it fell apart once it got to Congress, for reasons that anyone who knows anything about the United States Congress can understand why everything falls apart when it gets there, even back then. Now, what was interesting is around this time, a Court of Appeals case went up, and the people in the Klamath tribe said, even though we've lost our reservation through these allotment acts, the treaty said that we have a right to fish. And to have a right to fish, we must have a right to water, because what's the point of having a fishing right if you own no water rights? So they said, you have to give us enough water to maintain our traditional fisheries. And the court in the Ninth Circuit came back and said, you're right. These traditional fishery rights, you have a water right to enough water to maintain the fisheries, and your priority date in the prior appropriation regime is time immemorial, which means it put them right at the front. So they said, even though your land is gone, even though your land has been taken by the federal government, your fishing rights remain, and there is an pertinent water right to those fishing rights. And that water right is a right time immemorial at the very front of the line in prior appropriation. This gave the tribe enough leverage because now they're at the front of the line. If there's a call on the river, everyone after them can get shut off. It gave them enough leverage to bring new people to the table in a negotiation. The negotiation resulted in a new deal, this new deal to remove these dams from the Klamath River and restore traditional salmon fisheries. It has been driven by the tribes in the Klamath Basin. Part of this new deal is to integrate tribal traditional law into the agreements that are governing the management of the river. Now, one of the most important things that happened, and one of the most important results of the success of this deal has been the lack of involvement of the federal government. What the tribes, the cities, the towns, and the farmers all agreed to is don't talk to the federal government, leave them out of the room. And by leaving them out of the room, they were successful this time and reached an agreement that doesn't include the federal government. It meant buying out a bunch of federal land and federal regulatory authority on some of these dams, but it led to this deal. But part of this deal is also taking traditional laws that apply only on tribal land and extending their applicability across the basin. One of those is the Yurok tribe recognizes the legal personhood of the Klamath River, treating it like a legal person with rights. That has been Yurok tribal law for generations. It's integrated into their tribal constitution. Now it is a consideration across the entire river basin. I'm going to give you my opinion on this. I've worked in a lot of different countries that have river personhood. There are countries like Ecuador, India, New Zealand have various versions of legal personhood of rivers. I am not a fan, and I am skeptical of it. And here's why. First of all, people will sometimes come to me and say, well, the law treats corporations like people. Why can't it treat a river like a person? And my response is, corporations are people. All corporations are made out of people. That's what make up a corporation. It's just a group of people. There's no such thing as a corporation that isn't a group of people. And in that sense, a corporation is just like a church or a school or a city or an environmental protection organization. It's a group of people that has its own internal political process through which it can assert its rights and speak. A river isn't that. A river can't have a collection of way that speaks. In fact, a river is almost impossible to define. How do you define the boundaries of a river? And where does it begin and where does it end? And when is this one segment and it's another? So how big is the basin? So what ends up happening with legal personhood is it ends up just being a political choice of who gets a voice in the basin, who speaks for the river. Now, you might say, well, the government speaks for the river. First of all, is government very good at speaking for rivers? My experience is no. Which government gets to speak for the river? What if it's a transboundary river and there are multiple sovereigns in the river basin? Who gets to speak for the river? If you're going to create a multi-jurisdictional river basin commission, every single member of that commission is going to have to give up some sovereignty to the new commission. Are they going to be willing to do that? So the question of who speaks for the river just ends up being a political contest, and whoever wins it ends up having the most powerful voice. And I'm not sure why that's good. The other reason I'm skeptical of river personhood is a river is much more like a god than it is like a person. And I worry that in a legal regime where we speak of a river as a fragile being that needs our protection, rather than a mother who we depend on, it alters our relationship with the river. It makes us think that the river needs us and we don't need the river. And a better legal regime is one that emphasizes our dependence on the river. Because the more we know we need the river, more likely we are to engage in its protection. Because in the river's lifespan, it will tear down all of our dams. It will wipe out anything that we've done, and it will clean itself up, and it won't remember us. We need to protect the river for our sake. We don't protect the river for its sake. I say all of this with a ready acknowledgement that there are many scholars who I deeply respect, who are much smarter than I am, who have argued for legal personhood, and they're fantastic, and you should read their work, and I think it's excellent work. But at least in the context of the American legal tradition in the Western United States, I'm skeptical of its viability. So let's talk a little bit about the second issue, which is how we're quantifying tribal water rights. So in the United States of America, we've passed something called the McCarran Amendment. The McCarran Amendment is federal law that waives the sovereign immunity of the federal government and tribes to be sued in state court. So we have federal courts for federal issues and state courts for state issues. Normally, federal parties don't have to go to state court, in part because state courts often have elected judges. And if you're a Native American tribe, you don't really want to go to a court where the judge was elected by people who aren't going to re-elect you if you give a bunch of water to a Native American tribe. But in the 1950s, the United States government waived the sovereign immunity of the federal government as well as tribal entities to be sued in state court. The rationale was, if we're going to adjudicate all of the water rights in a river basin, then everyone who has water rights in that basin should be in the room as we're adjudicating it. Otherwise, there will be one adjudication in a federal court and another in a state court, and we don't want to have to struggle to reconcile two conflicting decisions. We'd rather there just be one decision for everyone. That's a good reason to have a general stream adjudication that includes the tribes, but the bad reason is that tribes tend to be in hostile venues when they're arguing for their water rights. They tend to be in local state courts, not in a federal court. Now, this only applies to comprehensive general stream adjudication. So only in adjudications where every single person who has water rights is included in court. These general stream adjudications are insanely complex and have lasted for a shockingly long period of time. The Gila River General Stream Adjudication, which covers that light blue area, was filed in 1974. There's no end in sight. It involves 113,000 claimants and over 500,000 claims. The Little Colorado River General Stream Adjudication in the dark blue was filed in 1978. It involves 93,000 claimants. I don't think it's exaggeration to say these are the most complicated court cases in the history of the United States of America. There's nothing to rival them. Now, why are they taking so long? Why can't we solve these? Part of it is just the sheer size. There's just too many people. So to give you a sense of the size, the state of Arizona is slightly bigger than the island of Great Britain. So this is a large area with a lot of people. The other reason it's taking so long is going back to how hard it is to define a river, which is in Arizona, as in many other Western states, we have a bifurcated water rights regime, meaning you have completely different laws that apply to surface water than to groundwater. But as all of you now know, being WSPMers, can you draw a bright line between surface water and groundwater? Of course you can't. What you do to one affects the other. But legally, we have to pretend like there's a sealed line between them. And that line is called subflow. Anything that's above the subflow line is surface water and belongs in the general stream adjudication. Anything below the subflow line, you get to go home. Well, guess what we spend all of our time arguing about? What's the subflow line? Now, there have been a series of interlocutory appeals over the years to the Arizona Supreme Court in this case. Interlocutory appeals are where we have a big question that we can't answer in trial, so we have to go to the Supreme Court. A whole series. They're named Gila 1, 2, 3, 4, 5, 6, 7. We all call them Gila, whatever sequence they were. Gila 3 is the one that decided that tribes have rights to groundwater. This was affirmed recently in a Ninth Circuit decision. But this means that for tribes, we are not just adjudicating surface rights, we are also adjudicating their groundwater rights. So groundwater, even though it's not supposed to be in a stream adjudication, is stuck in there. Gila 5 is another interlocutory appeal. And this is where the Arizona Supreme Court came and said, you know what? We think the way the United States Supreme Court quantifies tribal water rights is terrible. This practicably irrigable acreage. We don't like it. So we're going to take a new approach. And the new approach will be what we call the Gila 5 quantification method. And that is we're going to have a reservation-specific approach to quantifying tribal water rights. We're going to look at the tribe's historical use. We're going to look at their current population, their projected population, their economic base, their economic plans, the tribe's culture, and we're going to do a holistic, nuanced, tribe-specific quantification. Now, you might think, that sounds much better. Let's think about it for a second. So take a look at that map. That's a map of Arizona and all 22 of the federally recognized tribes in Arizona. So all the colored land is tribal land. So just to give you a sense of the size, that's slightly larger than the island of Great Britain. The Navajo Nation, who is just up in the very upper right-hand corner in the kind of peachish color, I guess, that is roughly the size of Scotland. Scotland has about 5.5 million people in it. The Navajo Nation has about 350,000 citizens. So a huge area, very sparsely populated, with very small communities that are very widely distributed. As you can see, the Hopi tribe is entirely surrounded by the Navajo Nation. The Hopi and the Navajo have their own very long history together that predates any colonization. The Navajo are largely linguistically and ethnically Apache. The Hopi are largely linguistically and ethnically Pueblo Zuni. And they have a long history of conflict between them that predates any Europeans showing up. And their land disputes have been as heated, if not more so, than their water disputes. But you can take a look at this map and get a sense for why quantification might be challenging. So take a look at the dark green just south of Phoenix. That's the Gila River Indian community. We sometimes refer to them as GRIC. Or the purple one right to the very western edge of the state, the Colorado River Indian tribes. We sometimes call them CRIT. You can see why they might like practically irrigable acreage. There's a big river running right through the middle of their land. They're an alluvial basin with really rich soil, so they want quantification based on agriculture. These are great farmers. They've got great farmland and a cheap and easy river running right through the middle of their land. They're old tribes with 19th century priority dates. So they're like, go ahead, federal law looks fantastic. What about the Hualapai tribe, that dark green one right at the base of the Colorado River, kind of in the upper left corner? The Hualapai tribe are a Grand Canyon tribe. The Hualapai have no gambling because of their own particular approach to their government. What they really care about is ecotourism. They want people to come to the Grand Canyon. They want people to go fishing. They want people to go whitewater rafting. They want people to go hiking. That's what they care about. But they're a plateau tribe, and their water source is the Colorado River, and it's way down at the bottom of the canyon. And the economic feasibility of pumping all that water up to the top of the canyon means that they don't get a very large practically irrigable acreage allocation. They want a different mode of quantifying their water right. So maybe they really like the new Gila 5 standard, and they would like a different approach. Now, I want you to take a look. These are all of the federally recognized tribes in Arizona. I just want to point out the vast majority have early 20th century or into the 19th century priority dates based on their treaty dates. The Tonto Apache has a 1972 priority date. Pascua Yaqui has a 1978 priority date. If there's a call on the river, those tribes will get cut off, and there's perpetual call in Arizona. Now, virtually every tribe has now settled their water rights. Why? Because they hate the general stream adjudications. Nobody wants to be stuck in court for 50 years and pay their lawyer for that long. So most tribes have settled. All tribes except for the Navajo, the Hopi, the San Carlos Apache, and the Yavapai Apache. Every other tribe in Arizona has settled its water rights. But because so many tribes have settled, we've never had to use the Gila 5 quantification method until right now. We have just finished 2 trials, and we're moving on to 2 more trials quantifying the water rights of the Hopi and the Navajo. This is the quantification for the Hopi in the Little Colorado River Basin's general stream adjudication. We quantified their DCMI, this is domestic, cultural, municipal, and industrial water, basically based on their future population multiplied by gallons per capita per day consumption. There are basically 3, well, let's say 4 broad groups in the trial. One we call the LCRC, the Little Colorado River Coalition. It's a group of miners, ranchers, farmers, cities, towns. It's basically everybody who isn't the federal government or a tribe, and they banded together. Then we have the Navajo Nation, who you can imagine the relationship between them and the Navajo is tense. In some ways, they want the Hopi to win because it means they might get better quantification, but they don't want the Hopi to win too much because they want the water too. So it's tribe against tribe. And then there's the federal government. And imagine the position the federal government's in. They are the trustees of the 2 tribes, and those 2 tribes are adverse to each other. But the federal government also owns the Grand Canyon National Park. So how can the federal government effectively represent 3 parties who are all adverse to each other in the same court proceeding? They do anyway. Well, one of the approaches we took to quantification of DCMI, domestic, cultural, municipal, industrial, was to go, well, why don't we just go look at other cities and towns that are close by to the Hopi and see how much water their people use. So we went to places like Winslow, Arizona, and Cottonwood, Arizona, and we asked them, we figured out what's your gallons per capita per day. And it was about 150. So we thought, 150 sounds good, let's call it 150. And a lot of people in the trial argued that the Hopi deserved a lot less. And I will tell you that those arguments I found pretty offensive. I am a very proud member of the Arizona water community. It's a good group of people. They are a kind and generous group. But I was disappointed in us in trial because most of the arguments about why the Hopi deserved less water per person per day than many of the white communities that surrounded them, they sounded to me like racism. And it was disheartening to see those arguments. And some of them would say things like, well, you know, the Hopi just don't use as much water as the people in Winslow and the people in Cottonwood. And I'd go, of course they don't. They don't have the infrastructure. If we build them the infrastructure, they'll use the same amount of water as anybody else will. We don't have any pipes or pumps or wells, so that's why they don't use as much water. If we turned off the water to Winslow and Cottonwood, they'd use a lot less water too. So I was disappointed in the outcome of that case, and ultimately the special master, who I'm going to brag a little bit here, but water law is by far the hardest area of law. It's like the deep end of the pool. I'm sure everybody else's little area of law is adorable and precious, but like water law is like real law, like really complex. And it's so complex that a normal judge can't do it. Like normal judges can do like freedom of speech and contracts and stuff, but they can't do water law because that's like grown-up law. And so judges tend to get special masters, experts in water law, who then make a recommendation to the judge, and the judge usually listens to their special master. So the special master in this case, who's not the judge, there's someone hired by the court to engage in special, they agreed with the LCRC, and Hopi were quantified based on a 90 gallons per day use. And then that was multiplied by their prospective population. The Hopi argued that they had 9,332 citizens now, they'd have 50,000 someday. The feds said they'd have 50,000 as well. The LCRC said just a little over 3,000. The special master agreed with the LCRC. So the DCMI quantification for Hopi was really disappointing to the tribe. Their economic development, they said, we're going to build a coal liquefaction plant. They've had a long-standing coal mining and coal-fired power plant on their land. They said, we're going to keep mining, and we're going to keep generating power, and we're going to develop coal liquefaction, take our coal and start using it to develop plastics. And they had 12 acre feet per year for a cattle farm. Hopi are some of the best cowboys in the West. They're really excellent cowboys. And 6,500 acre feet for a solar farm. This goes to the special master, and the special master said, we'll give you some for the coal plant, and we'll give you a little bit for a coal mine and none for your cattle. One of the interesting things about this is the tribe looking to have a lot of water for coal mining, which is complicated, right? So here's a tribal community who wants to exercise sovereignty over their own resources, but part of what they want to do with their resources is mine and burn coal. So it's tricky. They especially wanted to do this at a time when the price of coal was plummeting and the federal government couldn't even get bidders on federal coal rights. So one of the reasons they lost so much of the water they were seeking was because coal wasn't very valuable anymore, and they didn't think that coal mine was likely to be viable for much longer, as virtually every coal-fired power plant in the Colorado River Basin is scheduled for closure in the next 5 years. And then for irrigation, we've used something like practically irrigable acreage to determine it. And as you can see, again, the special master agreed with the federal government and the LCRC. Cultural water use was one of the most complicated ones because the Hopi people grow corn ceremonially as part of their religious practice. They grow different kinds of corn. They grow it in a particular way. They grow it in particular colors with different corn representing different aspects of their religious practice. The Hopi came to court saying, as part of our religious practice, we need a guaranteed source of water for our ceremonial corn growth. And the court came back and said, we don't acknowledge a cultural irrigation. There's culture and there's irrigation, but there's no such thing as cultural irrigation. And so it took a lot of expert witnesses and a lot of arguing over a long time to try and establish a cultural water use. And there were a lot of surrounding communities that came and said, well, we'll sell you corn. If corn is part of your religious practice, we'll just sell you the corn. And you can imagine what the Hopi said to that. This I actually don't think is racism. This was one of those instances where racism is a poison in the system, and it destroys relationships between neighbors, and it keeps us from finding equitable solutions. This I don't think is racism. This is a challenge I think we can overcome with education, with cultural exchange. I think there are people who just didn't understand the Hopi's religion, and if they had better understanding of it, I think we had a chance of getting it across the board. Ultimately, the LCRC and the feds argued against quantification of cultural water uses, and the Hopi got no water for their ceremonial corn growth. The final quantification, the Hopi claimed just over almost 162,000 acre-feet a year, and the special master awarded just about 29,000 acre-feet a year. Now you might think this is a massive defeat for the Hopi. It was a huge defeat for the Hopi people. But the little Colorado River never has a flow in it above 100,000 acre-feet in any given year. So what the Hopi were asking for was to own the river over everyone. So you can see why, and remember, they're competing in that river basin with other Native American tribes. So you can see why it's complicated. And these are the procedural questions. Objections were filed. It's now in front of the Maricopa County Superior Court judge. We'll see what the judge does. We just finished phase 1 of the Navajo Nation's trial. There will be a second phase. Phase 1 has been for their DCMI, domestic, cultural, municipal, and industrial. Phase 2 will be for their irrigation. We have a new special master and a new judge now, which is really frustrating because the judges that oversee the general stream adjudications are just regular judges. So they have divorce cases and criminal cases in front of them. And then they also have to handle the most complex litigation in the United States. I'm a big believer that we should change the system, that we should have specialized water judges who do nothing but handle these water law cases. But the turnover is also difficult because by the time a judge gets really good at water law after they've done this case for a few years, they rotate out and a new one comes in and you have to train them all the way back up again. The Navajo have claimed 143,000 acre-feet in irrigation with a total claim of just over 300,000 acre-feet. So the Navajo are also claiming to own 3 times the water that the river ever has in it. With an even earlier priority date. Phase 1 trial is over. Phase 2 will begin in 2027. What are the implications of this quantification? So a potential for settlement. The tribes are pretty disappointed in the outcome. Maybe they want to settle now. A lot of things have changed. For example, in the wake of COVID, a lot of federal money was put forward in different legislation to provide funds for settling tribal water rights claims. So there's more federal dollars in the system now than there will probably ever be again for tribes to reach out and get this money. So on the one hand, tribes have taken really bad defeats and they know trying to litigate this in court may not go their way. They could take it all the way to the US Supreme Court and see if they could win. That's a big bet. Or they could settle now with a bunch of federal money on the table. So we know what they're looking to do now. I've already told you about the closure of the coal-fired power plants. The precedent that this sets for Hualapai, for other tribes. So after these trials came out, the 2 other tribes that haven't settled, Yavapai Apache and San Carlos Apache, they watched the outcome of these trials and went, do we still want to sue each other? Or do we want to get out of this game now? Because it doesn't look like the courts are going to be very friendly. Is Hualapai constitutional? This is a state court telling the United States Supreme Court that it's wrong and going to do its own thing. Is that constitutional? Can a state tell the federal government we're not going to quantify federal rights the way you want us to. It may be unconstitutional, which means there's a chance, a non-negligible, this will definitely go to the Arizona Supreme Court. There's a non-negligible chance that this will go all the way to the United States Supreme Court. It's really difficult because a lot of the challenges of reaching a settlement mean trying to find small-scale, modular, adapted water systems, because these are small communities that are widely distributed, so there aren't economies of scale for some sort of big piped system to settle it out. So we have to be careful about tailoring our solution to the nature of the Hopi and Navajo populations. I've already told you, I think we should have a specialized water court in Arizona. Colorado has a specialized water court. I think we should do the same thing. And then implications for the broader Colorado River negotiations. We're about out of time, and I want to make sure people have time, but we'll talk a little more when I talk to y'all tomorrow about Colorado River issues. But as we're negotiating now for the Colorado River is taking a big hit. So we have, in 1922, the Colorado River Compact allocated 7.5 million acre feet to the upper basin and 7.5 million acre feet to the lower basin. 1944, we guaranteed 1.5 million acre feet every year to Mexico. We lose about 1.5 million acre feet every year to evapotranspiration. Add it all together, the whole legal regime assumes there's 18 million acre feet in the river every year. We know from tree ring analysis that the 1,000-year average amount of water in the river is about 13.5 million acre feet. So even if you waved a magic wand and reverse the effects of climate change, the river's still overallocated. Climate change is making the problem worse. What climate change is doing is, even though El Nino years, we get more frequent, more intense El Nino years, those El Nino years tend to bring us wet winters, but our wet winters tend to be short and hot. So even though we're getting 110% of our normal snowpack during these El Nino years, we're getting 30% of the normal runoff. So even though we're getting a lot of snowpack, the water won't hit the river, which means our reservoir levels are dropping. Depending on where you are in the river, we use 70 to 80% of the river is for irrigated agriculture, which is, there is no solution to this that doesn't involve agricultural issues. Reducing agriculture, though, this is thousands of jobs, and everyone in the United States of America eats Colorado River water every day, and especially in the wintertime. If you like winter vegetables, you eat Colorado River water. So what do we do with this challenge? Part of this is how we've allocated these decisions. Arizona's, California, Nevada are the lower basin states. So everything that flows downstream of that circle at Lee Ferry, everything downstream of that is considered the lower basin, and that is where the worst fights are. With the recent drought contingency plans and the recent Department of the Interior guidelines, these are cuts that we take at different elevations of Lake Mead, our main reservoir for the lower basin. Note that California takes no cuts. The reason is they're the senior user on the river. They have the highest priority date. So when there's a call on the river, Arizona gets cut first because we're the junior user. These are cuts under the recently agreed to lower basin drought contingency plan. As you can see, California very recently agreed to a cut. I might as well tell you the funny story if we have a second. So in the early part, in about 1933, we really hated each other's guts. California was building Parker Dam on the Colorado River, and Arizona had spies in the crew of Parker Dam. And when California crossed the river into Arizona, the spies warned the governor of Arizona that California had invaded. So Arizona created a navy to sail up the Colorado River and destroy the dam and kill the invading Californians. The federal government got word of this, marched troops out to stop Arizona from sparking a civil war. At the exact same time, federal martial law was declared and federal troops were marched out in a violent conflict between Oklahoma and Texas over the Red River, which was their river boundary. There's actually correspondence amongst the Third Reich generals at the time saying the United States won't enter World War II because they're about to descend into a water-based civil war. Now you might think, but everybody's calmed down since then. No. When we were negotiating this, the largest user in California has a right to 4.4 million acre feet from the Colorado River. Of that 4.4 million, 3.1 million goes to one irrigation district, the Imperial Irrigation District, where they have the most senior right. And we told them, we need you to agree to some cuts to keep the river alive, and they wouldn't agree to it. Ultimately, the Metropolitan Water District, which sells water to Los Angeles and San Diego, they agreed to take the cuts, which means they stabbed their fellow Californians in the back to get the deal across. And when we were signing the Lower Basin Drought Contingency Plan, the Imperial Irrigation District issued something, I'm going to get it close to word for word, the following press release. While congratulatory champagne corks pop, we remind our neighbors that the Imperial Irrigation District is the elephant in the room on the Colorado River. And like an elephant, our memory is long and our rage is great. Damn you all to hell. So now you have an idea of just how high emotions are running in the river basin. I'm not going to get into the current status except to say that this has led to a lawsuit from the Navajo Nation, as all of these ways that we're sharing in shortage, they expire in 2026. We do not know how we will share the river after 2026. We are frantically negotiating a new approach to this because we're about to expire. Navajo brought a lawsuit saying we are going to lose our water rights. We need to get into the game. They said the federal government owes us some plan to protect our water right. This goes all the way to the United States Supreme Court, and the United States Supreme Court said no. The United States Supreme Court said no for reasons I disagree with. What they said no to is that the United States has a fiduciary obligation to the tribes as their trustee, but unless there's specific language in the treaty about water, they owe them no specific fiduciary duty. I disagree with that. I think the whole point of the Winters case was that we read their treaties as if they say the word water. What I'm actually fine with is if the court had said something else. If the court had said, there is a fiduciary obligation to legally assert and defend the Navajo Nation's rights, but there is no legal obligation to provide the Navajo Nation with water until Congress has allocated the funds to build the infrastructure. Because I know the Supreme Court can't tell the Department of the Interior, build a bunch of pipes and pumps if they don't have the money to do it. But they can tell the Department of the Interior, you have to protect and defend the Navajo Nation's legal rights to the river. That I think they could have done. This has now led to real challenges for the Navajo Nation about what they're going to do, which has led to what we're talking about right now, which is a finalized settlement. What do tribal settlements generally look like? Usually the tribe will give up some amount of water they're legally entitled to in exchange for financing infrastructure, water infrastructure, in exchange for a moratorium around their land, pumping water around their land. Usually some diversification of their water supply portfolio. Will you bring us new supplies? And for authorization to lease their water off reservation. For a lot of tribes, the most valuable thing they own are their high priority water rights. And to be able to sell it to thirsty cities and towns is a huge economic driver for them. We've already talked about which tribes have settled and which haven't, but we are now on the cusp of a new settlement. Now this settlement proposal that was just announced has to go through Congress. So a lot of the heavy lifting of the lawyers is now done, and now it's in the hands of politicians, which is the scariest part. Challenges and opportunities for tribal sovereignty. So the trust relationship and financing, one of the hardest things for Native American tribes in the United States right now is they don't own their land, but they're sovereigns, which means they're immune. So they can't borrow money because they don't have enough, they don't own land to pledge as collateral in a loan. And even if they did, they're sovereigns, which means you can't sue them if they don't pay back the loan, which means they don't have any access to credit. So one of the things we can work on is expand tribal access to credit. One of the biggest differences between Navajo and Hopi is Navajo settled a massive uranium settlement case, and the Navajo Nation's government was very smart. They took all of that money, put it into an interest-bearing account, and it's now worth billions, which means Navajo, when they want to borrow money, they can. Hopi doesn't have that kind of thing, so Hopi can't borrow money. Sovereignty status and access to courts. When two states sue each other in the United States of America, it goes straight to the United States Supreme Court. That's not true when a tribe sues. I think that we should change the law so that when a tribe sues a state, it goes straight to the United States Supreme Court. We give the United Supreme Court original jurisdiction. Then the Navajo wouldn't have ended up in the situation that they were in their recent Supreme Court case, which took years to get there. I think we've seen more integration in these agreements, like we saw with the Klamath, and the potential for this new settlement agreement in the Colorado River Basin to integrate more tribal law, more delegations from the federal government to tribes to manage their resources, more tribal sovereignty in water markets. You're going to see a lot more tribes that are looking to sell their water rights to cities as they're looking for higher priority water rights to buy. And then water is a symbol of sovereignty. And this is what I'm in a story I'll end with, which is one of the most complicated cases I was ever mediator for. So I mediated a dispute between a Native American tribe and an irrigation district. And after months and months and months of work, the irrigation district made an offer to the tribe. They said, we will provide you 13 cubic feet per second of drinking water quality water piped to your border in perpetuity, 24 hours a day, 375 days, 365 days a year. And I went to the tribe thinking this was a pretty good offer. And the tribe said, no, we don't want their water. We want our water. And I'm going to be honest with you, I was pretty furious as the mediator. I thought this is as good a deal as you're ever going to get. And one H2O molecule is fungible with any other H2O molecule. What do you mean their water and our water? And it took a lot of humility on my part to shut up and listen. And I quickly realized that water in these disputes was a symbol of sovereignty. That we weren't really arguing about water. We were arguing about respect, and we were arguing about being treated like a sovereign nation and not like a random neighbor. And that's a key for representing any indigenous group, which is to understand when we're talking about water and when water is a deeper symbol. And as I know all of you have been in the WSPM program, you're all learning that water is often a symbol of something deeper, and that oftentimes when we're arguing about water, we're using water as a symbol of something broad and beautiful and ancient and difficult. So I will leave that there and open it up for a few minutes of questions. Thank you. Yeah.
Thank you so much for your talk. Super interesting discussion. I have previous work working at the UK with time.
Oh, great.
So, and in the Pacific. I was wondering kind of what your take is on the Lotus rule revision going on, and particularly potentially like the Trump rule and like the election coming up, and kind of like how you see this apply specifically to states in the Pacific Southwest with, you know, like more perennial water resources, and then like repealing coverage.
Right. So 96% of the waters in Arizona are ephemeral water bodies. So they are now outside, ever since the Sackett ruling by the Supreme Court, they're now outside of the protection of the Clean Water Act. What's really interesting, going back to tribes, is that the main party that brought the litigation to strike down the Trump administration's rule was the Pascua Yaqui tribe. So it's another instance of tribal sovereignty affecting the way we see water. They were ultimately successful, but the problem is that every time we sue each other in the United States, what ends up happening is every Republican majority state goes one direction and every Democrat majority state goes another direction. And then we just end up having this completely nonsensical regime. So this Sackett opinion went to the United States Supreme Court, and the United States Supreme Court basically adopted something even narrower than the Trump rule. Their rule was basically the only things that are covered by the Clean Water Act are traditional navigable waters, any relatively permanent tributary, meaning it flows seasonally, and any directly abutting wetland, and all other water bodies are outside the scope. What's going to happen now is those states that want to protect their water will pass waters of the state rule. Arizona has done that to protect waters that weren't covered. You will see more tribes seek for primacy under the Clean Water Act to protect their own water supplies, which is a tough decision for tribes because it's expensive to run the Clean Water Act program on your land, but it might be worth it to protect it under these circumstances. With a change in administration, isn't going to change this, because this is no longer about rulemaking. This is about the United States Supreme Court decision interpreting the Clean Water Act. The only chance now, if you really don't like Sackett, is to amend the Clean Water Act. And given the state of American politics right now, getting that through Congress is really tough. Yeah.
I have a quick question about like funding and specifically in regards to like infrastructure financing for like federal tribes within the US. I think like one of the biggest issues that I've seen is there's all of this funding coming from the federal like government level, whether that be through like the drinking water revolving fund, the infrastructure, the like and other like tribal funding as well. And there's like a lot of difficulty at the local and municipal level of like actually leveraging that funding or accessing those grants, just because there's such a, it's just like so disparate between the federal level and the local level. So I'm curious of like, if you know of any places where it's really been successful leveraging that kind of money, or like what channels exist so that like tribes without the institutional knowledge about how to get grants can access.
Oh, now you're really bringing up a big issue, which is one of my pet peeves is when people say the tribes want this or the tribes think that. There is no tribes. The tribes just in Arizona alone are incredibly diverse. They're diverse ethnically, linguistically, they're diverse geographically, economically. They're very different from one another and often at adverse interests. And so the tribes don't think anything. They think lots of different things. There is no tribal interest. There's lots of different interests, depends on the tribe. And I've seen some tribes that are really good at it. You know, there are tribes that are hyper sophisticated, that have outstanding lawyers, are really good at getting grants. Right now, I sit on the Water Infrastructure Finance Authority for the state of Arizona, and it's been really frustrating because you'll watch tribes that have amazing grant writers, and they will come with the most sophisticated application. And then you'll have other tribes that will come, and you can tell that is one overworked water manager in an office by themselves, giving it everything they've got, and they're just too busy to come up with something good. Where have I seen it work well? Where I've seen it work well has actually been in beaver restoration habitat. I don't know if that's because Fish and Wildlife has just been better at it than EPA with the Drinking Water Revolving Fund, or like, Bureau of Indian Affairs with a lot of healthcare stuff, so like particularly bureaucratic and frustrating. But for some reason, Fish and Wildlife with beaver habitat restoration has actually been relatively successful. And I think it might just be the nature of Fish and Wildlife. And it's also been because you're watching a lot more ranchers in the West opening their eyes to the value of beavers for ranching. They're like, you know what? We killed all of these beavers. Turns out that was a really stupid thing to do if you like cattle. Yeah.
So I'm up in Canada, and British Columbia itself has like over 215 different nations. And the way that we're approaching watershed is really trying to like address FIPR directly. And one of the things that I think we sort of talked about what we should do is start registering water use. So, and I feel like that would save a lot more time, money, capacity, and resources. Is there a reason why that's why?
Yes. So part of the negotiations about the Hopi Nation's cultural water uses was, we know that you're getting that water from somewhere because you're using the cultural uses now. Tell us where you're getting the water from so that we can include that in our models. And we know there are sacred springs that the Hopi rely on for their ceremonial corn growth. And they will not tell anyone where they are for understandable reasons. They do not trust anyone who's an outsider. And I've worked all over the world on water issues. There are so few universals in water. Countries and cultures, laws are so different. It's hard to say anything broad. I found one universal. It is true on every country, everywhere, on every face of the earth at all time. And that is, rural people don't want to meter their wells anywhere in the world. My solution to this is to tell people, listen, the value of your knowledge about your groundwater supply is never going to be higher than it is right now. The more sophisticated our satellites become at detecting changes in groundwater movement, the less valuable their traditional knowledge becomes. Because the day is not that far off that between machine learning, AI, and satellite imagery, we're going to know where that water's coming from anyway. So the time is now for anyone who has information about their groundwater to monetize it. If they want to trade it for something, this is the moment. But it's hard to compel people to do that. So my attitude is, let's give people the right incentive. What if you record a deed restriction on your land that says, we will promise to disclose where the location of our well is, and we will install a smart meter on our well that will transmit its pumping capacity. And in exchange, we get a property tax break. For tribes is a little bit different, but one of the things I think we could do for tribe is to give them some incentive by building up a trust fund that allows them to borrow against it as collateral and a loan, so that we build up their ability to get credit. This might be a little bit different in Canada, but those are some of the ideas I've had, at least in the context of the States. Yeah.
Yeah, I'll just going to ask, first of all, thank you for your presentation, really good insights, especially at the tail end where you highlighted that water promotes deeper, implications and not just the stuff that we're talking about. And I was just wondering, given your comments also about the shortfalls of current jurisprudence, in navigating or in transitioning towards better law, if you comment on the scope of opportunities in terms of career, where as WSPM students, they'll be going forward some of the areas we could look at, because it was one thing that also became clear when this week we spoke about the human rights watch and how that is leading to a lot of seats, around the world when it comes to criminal, issues relating to water rights.
So if you're interested in going into water law, obviously it's going to depend on the country, because every country is a little bit different when it comes to certifying attorneys. So you're going to have to look at the certification requirements in the individual country that you're interested in. If what you're interested in is international water law, there's a small cohort of us that practice in international water law. And I'll be honest with you, I got into international water law kind of on accident. I represented a small mining company, and they had operations near the Mexican border, and they had pollution that was spreading across the Mexican border. I was the only lawyer they had that could speak Spanish. So they hired me to negotiate with the Mexican government about how to clean up the pollution. And after I did that, my client was like, "Oh, you speak Spanish? We have mining operations in South America." And then once they did that, they were like, "Oh, we have mining operations in South America. We're building a desalination plant." And then there were these people in Dubai who were like, "Oh, well, you do desalination plant." So that's kind of how I got into the international side. But doing international water work it's a small group of people who do it, and they usually got into it like I did, kind of on accident. So my advice about getting into international water work is be multilingual. That helped me. And I would say, work in water issues that are transboundary at the domestic level, and then watch how that might transition you. But I will say that for people who are interested, a career in water law is a really satisfying thing. I love being a water lawyer. It's incredibly challenging, but it is a constant learning opportunity. And a lot of people are like, "Oh, I don't want to make a bunch of arguments and stand up in court and scream." The vast majority of my career as a lawyer has not been in courtrooms arguing. It has been in boardrooms negotiating. It is about finding solutions to problems and mediating and getting people to come together. It's not about winning cases mostly. It's mostly about settling disputes. I tell people all the time, like, law practice at its peak, a true lawyer is a peacemaker. A true lawyer knows how to bring peace. They don't foment conflict. Yeah, David.
One of the great things about being in water science policy and management from the beginning and having seen it the whole way through is listening to and seeing old students or former students, not old students, former students.
My kids think I'm old.
And I think that was an absolutely brilliant lecture, and I appreciate that very much. And it gives me great satisfaction. For the rest of the class, I remember Rhett when he was just about to make his presentation about what he was going to do for his dissertation. And there was a whole classroom there, and I was sitting in the audience, and Rhett stood up. And I can't remember who it was sitting beside me. It might have been Michael Rouse. But when Rhett started talking, the person next to me said, "My God, he's addressing a jury." That's what it was like. You were addressing. I have one question. Well, two little questions. One, you described the area in Arizona. Where else in the States are there similar issues? That's one question. And the other one is, are there all these issues in Arizona having a major conflict on other adjacent states?
So these sort of tribal issues are all over the Western United States. Every single state in the Western United States has a general stream adjudication. All of them do. The most heated general stream adjudications, not surprisingly, occur in the states that have bifurcated water rights regimes. So if you have an integrated regime where surface water and groundwater are treated legally the same, they solve their stream adjudications relatively quickly, within 5 years. For states that have bifurcated regimes, they never die. So bifurcated regimes include Texas, Oklahoma, Nebraska, and Arizona, and California. And our stream adjudications go on forever and ever and ever, and they never end. So those are the 5 states where Texas, Oklahoma, Nebraska, Arizona, and California are the 5 where we just can't solve the problem. And that is the number one reason why, is bifurcation. Is it having effects on others? It's having a massive effect on others, because negotiating this settlement, Mexico relies on 1.5 million acre feet every year from the Colorado River. And until this is resolved, they every year have to negotiate a new amendment to their treaty to figure out a new way to settle how they will share in shortage. Every single farmer, rancher, city, town downstream of the Navajo Nation, so everyone in Nevada, Southern California, and Arizona, there's this enormous uncertainty because the Navajo Nation, we sometimes refer to them as the compact buster or the sleeping giant because their land is so huge and their water right is so senior that imagine if their PIA calculation was 500,000 acre feet a year. It's not insane. They're claiming 300,000 acre feet in the Little Colorado River. That's more water than the entire state of Nevada gets from the Colorado River. So if they all of a sudden get that amount of water, it disrupts everything downstream of them. So everyone is interested in the outcome of this settlement. And I will also say, just with having David in the room, how grateful I am for him and for the teachers and friends that I made here. I would not be where I am right now if it weren't for WSPM and my experience. Some of the best friends I have in the world were my classmates, and I am an infinitely better lawyer, an infinitely better water policy planner, and a better person for having been in the cohort here. And I am just deeply, deeply grateful to everyone who made that experience possible. Thank you. And we get to talk tomorrow too. That'll be super fun. You bet. Tomorrow we're going to talk about water rights in outer space. I know. Joe, thanks.
I agree.